I want to start off with a sentence that was written by a judge. It's from an opinion handed down by the New Mexico Supreme Court on July 30th of this year. And it's about what happens when a doctor is legally required to call the police about a patient. The court wrote that the purpose of that reporting requirement is to cause a law enforcement investigation to be initiated. But once the report is made, the physician's duty ends, and the law enforcement's duty to investigate begins. And then this part. Outside that narrow exception, all confidential communications between the patient and the physician remain privileged. They are not at all automatically converted into unprivileged communication. That's the whole thing. That's the ruling. What it means in plain language is that mandatory reporting is a keyhole. It is not an open door. And because of that sentence, a jury in Eddy County, New Mexico will almost certainly never see the single most watched piece of evidence in a case that a very large number of people have already decided they understand. The evidence is police body camera footage that was recorded in an emergency room in Artesia, New Mexico, in the early hours of January 27, 2023. If you've seen it, you probably remember how it made you feel. If you've only read about it, you almost certainly absorbed at least one detail about that night that appears to be wrong. Today, we're going to walk through what actually happened, what's actually been established, and what a court just decided the rest of us are not entitled to use. Welcome back to The Human Pattern. I'm Liv. Before we jump in, if you're curious about why people think, feel, and behave the way they do, I'd love for you to subscribe or follow the podcast. And if you find yourself leaving an episode with more questions than answers, then you're exactly where I hope you'll be. So subscribe wherever you're listening so you don't miss future conversations. And this one is going to be a two-parter. Today is the story. So what happened that night and what a court decided about it 3.5 years later. Part two is the part I genuinely have not been able to stop thinking about. Why this happens so much more often than any of us realize. Why almost everything we've built to prevent is pointed at completely the wrong moment. And what it actually means to charge a 19-year-old with first-degree murder. And don't worry, I won't make you wait a week for it. Part two is going to drop Thursday as a bonus episode. Okay, two quick things, and then I promise I will stop being the disclaimer person. First one, this case is still open. Alexee Trevizo has pleaded not guilty, and none of this has been proven. So I'm going to be really careful today about the difference between what a document says, what a video shows, and what actually happened. Those are three different things, and they get treated like one thing constantly. Second one, there is a baby at the center of this. He was named Ray Fierro. I'm going to use his name because he had one. All right, let's get into it. So, just before midnight on January 26th, 2023, a 19-year-old high school senior arrived at the emergency room at Artesia General Hospital with her mother. Artesia is a small city in the southeast corner of New Mexico. At the 2020 census, it had 12,875 residents. And I want you to hold on to that number because it's going to matter enormously in part two. Alexee was there for severe lower back pain. According to the New Mexico Supreme Court's account of the record, she told the emergency room department physician, Dr. Heather Vasquez, that she was not pregnant. She was given intravenous medications, including morphine, and the physician ordered a pregnancy test. Now, I want to be clear about that because it does get lost. Ordering that test was correct. It is standard practice for those symptoms in a patient of that age. That is a hospital doing the right thing. The test came back positive. Now, here's where I have to stop and flag something, and it's the single most contested fact in the entire timeline. According to the New Mexico Supreme Court, when the result came back, Trevizo was not informed she was pregnant until police were already present in the room with the physician and her mother. Read that again in your head and notice what it does to the sequence. It means the hospital had a positive pregnancy test in hand, and per the court's recitation of the record, she had not been told. A number of national outlets have reported the opposite. You'll find coverage describing her as having gone into a bathroom after being told she was pregnant. That version is out there widely, and it has shaped how an enormous number of people understand this case. I'm going with the court's account because it's the primary source and it's the version that survived appellate review. But I'm not going to pretend that settles it. Reporting genuinely conflicts, and if this case goes to trial, testimony may resolve it differently than either version. I'll say so if it does. That flag matters more than it might sound like right now, but by the end of part two, it's going to be load bearing. A little over an hour after treatment began, Alexee asked to use the bathroom down the hall. She was in the bathroom for somewhere in the range of 17 to 20 minutes. Custodial staff were later summoned to clean blood in the bathroom and the hallway. While cleaning, a member of the housekeeping staff found a newborn in the trash can. He was in a plastic bag that had been tied. A second bag had been placed over the top of him. Police were notified. Now, I'm going to move through this quickly, and that's deliberate. There is a version of this episode where I spend 8 minutes on the physical details of the bathroom, and I could. The arrest affidavit contains descriptions from cleaning staff that are genuinely difficult to hear, and reading them out loud would absolutely hold your attention. But I'm not going to, for two reasons. One is that Alex Ray Fierro is not a set piece, and then the other is more practical. Everything worth understanding about this case lives in what happens next and why it keeps happening. And I'd rather spend the time there. So, meanwhile, in a different part of the same building, something else was happening that gets left out almost every version of this story. Lexi was bleeding badly, badly enough that her physician arranged an emergency transfer to another hospital. The court described it as ongoing, life threatening blood loss. She had just given birth, alone, on a bathroom floor, at 19. She was hemorrhaging. She was on narcotics. Whatever else was true that night, this was also true at the same time, in the same body. Here's the sequence the Supreme Court found in the record. Dr. Vasquez spoke to police first. Then she entered Trevizo's hospital room, bringing two officers with her. The officers stood in the doorway. Their body cameras were recording, and she told Trevizo and Trevizo's mother that a dead newborn had been found. Trevizo's recorded response was that she was sorry, that it came out of her, and that she didn't know what to do. She also said she held the baby and that there was no movement, no breathing, nothing. Her mother asked her what she did with it. That footage is what everyone has seen. It is, by an enormous margin, the reason this case became a national story rather than a local one. And I want to be careful about how I describe it, so let me be explicit about my own language for the rest of this episode. When I say the footage depicts something, I mean the footage depicts it. I'm not going to tell you what happened in the bathroom because I don't know, and neither does anybody else who wasn't in it. There is a second piece of the footage that got far less attention than it should have, and it's the part I actually really want to talk about. Speaking to responding officers, the charge nurse gave an account of what had happened. He said the patient had just given birth, that it happened in the bathroom, that the baby was dead, and then, quoting the footage, she killed the kid. That statement was made within minutes. No examination, no autopsy, no toxicology, no pathology of any kind. And I want to separate out two different problems in that clip because they get bundled together and they are not the same size. The first is a legal problem, and it's genuinely contestable. A nurse relaying facts to responding officers is at least adjacent to the mandatory reporting duty we opened with. Reasonable people can argue about where that line sits, and in a moment, we'll see that a court did exactly that. The second problem is not a legal problem at all. It's the bigger one. The baby is dead is an observation. She killed the kid is a conclusion. And in that moment, Nobody in the building had any basis whatsoever for the second one. Not the nurse, not the officers, not the physician. The information that could support or refute it simply did not exist. It would not exist for 2 more months. Now, watch where that conclusion traveled. It went into the police narrative that night. It went into the arrest affidavit. It went into the charging decision. It went into national coverage. It went into a petition to bar her from attending New Mexico State University that gathered more than 20,000 signatures. At every stage, it got more solid. And at no stage did anyone go back and check whether it had ever been supported in the first place. Here's the thing I want to be fair about. I don't think that the nurse was acting in bad faith. He walked into a bathroom in the middle of a shift and found a dead infant in a garbage bag. His brain did what humans do, which is assemble a coherent story out of an incoherent scene, fast and with total confidence. That's not a character flaw. That's the same mechanism I've talked about on this show before, the one that fills a gap the second it appears. The problem isn't that he had a theory. The problem is what the system did with it. Because a first responder's instant read is supposed to be an input. In this case, it functioned as a finding. And there's one more moment in those recordings that I just have not been able to stop thinking about. At one point, while giving an account to detectives, the charge nurse says out loud, and this is just speculation, sit with what's actually happening there. This is a person doing the responsible thing. That is somebody noticing in real time that he has crossed from what he saw into what he's guessing and saying so, and then continuing. And the detectives don't redirect. Nobody says, let's stick to what you actually observed. It just gets written down along with everything else. Here's why I think that matters more than what it looks like it does. That caveat does not travel. The phrase, this is just speculation, attaches to the moment it was said. It does not attach to the content. 6 months later, when that information has moved through a report and a conversation and a summary and somebody's memory, the speculation is still in there. The label is gone. Caveats fall off. Claims survive. And I'd put the weight of that on the detectives rather than on the nurse. Honestly, a nurse in the middle of a shift is not trained in evidentiary interviewing. Separating observation from inference is not their job, and nobody should expect it to be. It is exactly, precisely the job of the person holding the recorder. There's a piece of this I only learned recently, and it changed how I think about that night. Months later, in a court proceeding, Dr. Vasquez was asked why no attempt was made to resuscitate the baby, and she gave 2 reasons. The first was clinical, her immediate evaluation of the infant. And I want to be genuinely fair here, because that reason can stand entirely on its own. There are established guidelines for when resuscitation is not attempted on a newborn. If an infant shows no signs of life and there's no way to know how long that's been true, withholding resuscitation is a recognized and defensible medical decision. If that had been the only reason given, there would be nothing to talk about here. But it wasn't the only reason given. The second reason was not wanting to disrupt what might be a crime scene. I've been sitting with that one for a while, and I want to be careful about what I am saying and what I am not. I don't know Dr. Vasquez. I wasn't in that bathroom. I have no idea what it's like to walk into that at the end of a shift at a small hospital, and I'm not interested in making this about her as a person. She's a human being who had a terrible night. But I do think that sentence is the clearest illustration of something this whole story keeps circling back to. Because a physician has a duty of care, and that duty runs to the patient. A physician does not have a legal duty to preserve a crime scene. That obligation does not exist. It isn't a thing. So, of those 2 considerations, one of them was her actual job. The other one belonged to somebody else in that building. And here's the part I don't think anybody can resolve. We will never know whether the second reason changed the outcome. It's entirely possible the first reason was completely sufficient on its own, and the second was just something she noticed and mentioned later. It's possible she would have made exactly the same call in an empty hospital with no police within 50 miles. But we can't know that. And honestly, neither can she. That isn't how the mind works. You don't get to run the counterfactual on your own decision. What we do know is that it was in the room. The consideration was present. It was available. And months later, under oath, it was one of the two things she named. Now I want to go back to the motions that had been filed in this case. Two outside groups argued that law enforcement doesn't belong in emergency rooms. Their argument was mostly about patients, that people will not seek care if care comes with a police officer attached to it. This is a different version of that problem, and I think it's a sharper one. It isn't only that police presence changes what patients do, it's that it changes what the room is for. Here's what didn't happen next. Alexee wasn't arrested, she wasn't held, and she wasn't charged. She was treated, transferred, released, and then she went home with her mother. She went back to school for 4 months. Nothing happened. And I think a lot of people, when they hear that, hear it as a scandal, as evidence that something went wrong, that someone dropped the ball. I want to say it plainly that I understand that reaction, and I don't think it's cheap. A baby died, and for 4 months, from the outside, it looked like the world simply carried on. If you cared about Ray Fierro, or if you're the kind of person who cannot stop thinking about a newborn in a garbage bag, 4 months of apparent nothing is not an abstraction. It's unbearable. So I'm not going to talk you out of that feeling. But I would ask you to consider the other reading. The state didn't have a case yet. The autopsy findings came on March 28, 2023. The infant was determined to have been born alive. Cause of death, asphyxia. Manner of death, homicide. Alexee was arrested on May 10th after what was described as a 4-month investigation and charged with first-degree murder and tampering with evidence. So the 4 months of nothing aren't a failure. They're the system doing the thing the nurse didn't do, which is wait for evidence before reaching a conclusion. Now, one important note on that autopsy, and I will be coming back to this in part 2 because it deserves more room. The question of whether a newborn was born alive or was stillborn is still one of the hardest questions in forensic pathology. It is not a simple test with a clean answer. I told you I'd be precise about what's been established. So here's the precise version. The autopsy concluded he was born alive. The defense disputes it. That conclusion is the entire foundation of the murder charge. And in part 2, we're going to look at exactly how forensic pathologists try to answer that question and how confident anyone is entitled to be about the answer. On May 18th, 2023, 8 days after her arrest, Alexee was released on a $100,000 unsecured bond with conditions. She attended prom, he attended her graduation, photographs circulated, and the reaction was, I think it's fair to say, incandescent. A petition to bar her from New Mexico State University passed 20,000 signatures. Her attorney publicly dismissed it as prejudice nonsense. I want to sit here for a second because this is a place where two systems ran into each other and produced something that feels like a contradiction, but isn't. A judge looked at a defendant with no prior criminal record, weighed flight risk and danger to the community, and released her on conditions. That is what pretrial release is for. It's not a statement that she's innocent. It's a statement that the state hasn't proven otherwise yet, and that holding people who haven't been convicted is supposed to be the exception. Meanwhile, several million people looked at the same facts and convicted her in about a week. Both of those things are functioning exactly as designed. The presumption of innocence is a legal doctrine. It has no social equivalent. There is no rule of the internet that says you have to wait. And I gently point out something about the photographs specifically. Because it connects to something we covered in the bonus episode on the insanity defense. The photograph of a person at prom tells you what one frozen moment looked like from the outside. It's genuinely not information about what is happening inside a person's mind. It never has been. We just really, really want it to be. In August of 2023, an Eddy County District Court judge granted a defense motion to suppress. The body cam footage, the hospital surveillance video, and Alexee's statements were all thrown out. The state appealed. The case sat. Along the way, the New Mexico Supreme Court accepted friend of the court briefs from outside groups, including the ACLU of New Mexico and the National Police Accountability Project, who raised concerns about law enforcement operating inside emergency rooms. On July 30th, 2026, 3.5 years after that night, the New Mexico Supreme Court ruled unanimously. Justice Michael Vigil wrote the opinion. The district court was affirmed. The evidence stays out. Almost every headline about this compressed the ruling into some version of she didn't waive her rights. And that's not wrong exactly, but it flattens three specific holdings into one. And the flattening is a big part of why the public reaction went the way it did. So let's take a look at them one at a time. Holding 1. The state wanted a rule that if a third party who isn't necessary for medical care is present, privilege is automatically waived. Full stop, every time, regardless of circumstances. The court rejected that outright. It said adopting that rule would be inconsistent with existing case law and with the entire policy purpose of physician-patient privilege. Instead, it laid out requirements that the patient has to actually know the third party is there. The patient has to have the mental and physical capacity to waive, and the waiver has to be voluntary, judged against the totality of the circumstances. That's the durable piece of this ruling. It'll get cited for decades in cases that have nothing to do with newborns. Holding number 2, applying that test, the court found the facts unequivocally demonstrated she lacked capacity. The language is unusually direct for an appellate opinion. The court described her as arriving in excruciating pain, administered numerous medications, including narcotics at unknown doses, having given birth, and suffering ongoing life-threatening blood loss. And then it said that despite her unresolved medical crisis, the physician, without authorization, ambushed her, bringing 2 armed officers who stood in the doorway and disclosed her personal medical information to everyone in the room without warning. It noted she was given no opportunity to exclude anyone from the room first. That's the state's highest court, unanimously, using the word ambush. Holding number 3, and this is the one from the open. The state's strongest argument was the one that sounds most reasonable to most people. Doctors are legally required to report suspected child abuse. So how can privilege possibly apply? The court's answer was the keyhole answer. The purpose of the reporting requirement is to start an investigation. Once the report is made, the doctor's duty ends and law enforcement's begins. Everything outside that narrow act of reporting stays privileged. The duty is to make the call. The duty is not to become an arm of the investigation. Okay, so if your reaction to that is, wait, what? I want you to know I'm not going to talk you out of it. There's a recording. On the recording, a person appears to say something, and a court just decided a jury doesn't get to see it. That's a genuinely strange thing for a legal system to do. If your gut is telling you something went wrong here, your gut is not being dumb. So let me offer you a different way to look at it, and then you can do whatever you want with it, honestly. Privilege rules are not written with the sympathetic defendant in mind. They're not written for this patient at all. They're written for the next one. The question the court was actually answering wasn't, should Alexee Trevizo be convicted? It was, what is the relationship between a hospital and a police department in the state of New Mexico? And the answer it gave was that a physician can be required to pick up the phone and cannot be turned into an investigator. If the rule went the other way, the cost of that rule doesn't get paid by her. It gets paid by every frightened person in New Mexico who now has to weigh, before walking into an emergency room, whether the doctor treating them is going to bring officers to their bedside. That's not something defense attorneys made up to sound noble. It's the whole reason those outside groups filed briefs in the first place. And look, here's the uncomfortable part, and I'd rather just say it than dance around it. A rule built to protect people who need care is sometimes going to protect somebody you really wish it wouldn't. That's not a bug in the rule, that's what a rule is. So, is this case over? No. And I want to be careful here because a lot of coverage has implied that it is. What got suppressed was her statements, the police body camera footage, and the hospital surveillance video of her inside the building. What the ruling did not touch is the autopsy or the physical evidence recovered from the bathroom, or, in principle, hospital staff testifying about what they saw with their own eyes, which is a different category from privileged patient communications. The state's case is badly wounded, but it is not obviously dead. What happens next is a decision by the district's attorney's office. And as of this recording, that decision hasn't been publicly announced. There's also a second proceeding running alongside of all of this, and I want to describe it accurately because almost everyone gets it backwards. There is a wrongful death lawsuit over Ray Fierro's death. It was filed by Trevizo's own attorney on behalf of the infant's estate against Artesia General Hospital, against Dr. Vasquez, and against emergency room staff. The theory is that the hospital administered medications not recommended in pregnancy, that this caused the infant to stop breathing before birth, and that staff missed opportunities to intervene. It also alleges the hospital was wrong to allow officers to record inside the hospital. A medical malpractice attorney interviewed about it on another program called the approach desperate and dangerous, and argued the amount of morphine found at the autopsy was far too small to have caused death. I'm not going to tell you which of those is right because I don't know, but I'll note the two standards are different. A criminal case requires proof beyond a reasonable doubt. A civil case requires a preponderance of the evidence, which means it is entirely possible for those two proceedings to reach conclusions that look, from the outside, like they contradict each other. And it wouldn't mean the system malfunctioned. It would mean they were asking different questions. So here's the thing I want you to actually walk away with. A charge nurse walked into a scene and within minutes had a whole story. Beginning, middle, an actor, a motive, the complete thing. And he wasn't being malicious. He was doing the fastest, most human thing there is, which is to close a gap the second one opens. You do it. I do it. I've done it 3 times today. But then the story traveled and it hardened. And by the time real evidence showed up 4 months later, most of the country had already finished the case. So, this week, when you hear about something that just happened, see if you can catch the moment your brain hands you the finished version. Not the moment you decide, the moment right before that. The moment the story just sort of arrives, already complete, and it doesn't feel like a conclusion at all. It feels like you're simply noticing something. And then ask yourself one thing: what would I have to actually know for this to be true? And do I know it? That's it. That's the whole assignment. You don't have to change your mind about anything. You just have to notice the seam. Part 2 of this episode drops on Thursday, and here's what we're getting into: how often this actually happens, and why the honest answer is that nobody knows. Because a newborn who is never registered as born is very hard to count as dead. The difference between a woman who hides a pregnancy and a woman who genuinely does not know she's pregnant, which, it turns out, are two completely different things that our legal system treats as one thing. Safe haven laws, and why I've come around to thinking that the box on the side of the fire station solves the last 5 minutes of a 20-hour problem. And the question you've most certainly already been sitting with. She was 19, legally an adult, developmentally nowhere near finished. What is that supposed to mean for a first-degree murder charge? One more thing before I go, and then I'll let you get on with your day. The most important sentence in this entire episode was the one I flagged way back in the beginning. A hospital had a positive pregnancy test, and according to the state's highest court, the patient had not been told. I don't know yet whether that's what happened. The reporting genuinely conflicts, and if the record ends up showing something different, I'll come back on this feed and say so. But if it is what happened, then everything we talk about on Thursday is going to hit very differently. If this episode changed how you're thinking about a story you've already decided you understood, I would love to hear about it. Links are in the show notes, or feel free to drop in a comment. Make sure to subscribe wherever you're listening, and if you're enjoying the human pattern, a rating or a review really helps more people find the show. So until next time, stay curious, question the pattern, and I will see you in the next episode.